today or tomorrow at 2 o'clock. Urgency is there, Lordship.
When did you file?
Today, Lordship.
Friday.
Friday, he doesn't extend it work for Lordship. So tomorrow, Lordship, if possible.
Tomorrow boat is full, but that is the difficulty. As you know,
Urgency is there, otherwise, Lordship, I'm not paid.
you have the filing number with you.
Lordship, I have given.
Okay.
Oblige.
May I please, your lordship? Your lordship, I beg for listing of admission stage, your lordship, of a bail application, 141 days behind the bar, your lordship. Friday may come up, your lordship, urgency, your lordship. Admission there.
When did you file?
Your lordship, we have filed an additional affidavit, your lordship. Much obliged.
May I please, your lordship? I would like to mention item number 37. It is an anticipatory bail, but I need some time to file a written objection and a CD has also been called for. IO is out of his station for certain investigation purpose. 1 week time may kindly be granted.
Give us a date,
Yes.
specific date.
Okay.
Give us a specific.
4th or 5th of June. 5th of June.
Have you informed the other side?
No, well, I could not able to contact, but I
Okay,
would like to submit that probably there is some interim protection is there. So it is up to the lordship.
In this matter, interim may continue.
Is it? There is interim?
Yes, one interim protection is there.
Okay. On 5th.
5th, much
Yes.
of.
Lord, I have to mention one motion matter may be taken day after tomorrow matter.
When did you file?
Yesterday matter. I have got the number matter. Alright.
Wait, please, your lordship. Mentioning for August, Lordship. Can it be taken on Friday? In the order column.
Why is so urgency?
Lordships, justice service was allowed by the court. We have served them, Lordship.
You have filed the affidavit.
Lordship, that affidavit is.
May please,
Okay.
Lordship. Lordship, I am praying for listing of bail application for withdrawal, madam. Tomorrow, if possible. Deeply obliged.
May I please, Lordship, Lordship, I beg to mention item number 4, my lord. My lord, matter may be adjourned for the day, my lord.
Much obliged. May I please, your lordship? Your lordship, I beg to mention item number 16. Matter may be adjourned for the day. Lordship, may fix
Item number 10.
Yes.
Lordship, I beg to mention for listing for withdrawal, Lordship, tomorrow.
Yes, please, your lordship. Lordship, I beg to mention for listing of a criminal petition next week, my lord, any day. For admission column. It was last posted on, my lord, 5/2/25, my lord. But due to paucity of time, my lord, it could not be reached, my lord.
Court.
Much obliged, my lord.
Lordship, I beg to mention item number 15, Lordship. Matter
1/5.
may be fixed after 1 week, Lordship.
1/5.
1/5, Lordship.
Lordship, I beg to mention item 23, the matter may be adjourned for the day.
So go for the week, not for the.
There is an interim order that may be continued.
From which police station?
Lordship, I am appearing on behalf of SO, Lordship.
This could be as well.
You have the case diary?
No, no.
Mr. Botakur, when? Give a specific date.
Yes, my lord.
Don't give a date when the case diary will not be available for you.
On 5th of June, my lord.
Are you sure you'll have the case diary?
Then
6th of June.
6th of June.
There is interim.
Yes, sir.
Case diary. Yes.
Nice.
Yes.
Yeah, but Lordship, I beg to mention item number 27, Lordship.
27 CD received, my lord.
Are you in interim?
No, Lordship.
There is no interim.
No.
Retain the case diary.
I'm trying for listing of a criminal petition, madam, for listing, madam.
When did you file?
Well, the old case, madam. Last detail on 12/2, madam.
Court.
Obliged.
Medical. You are
20.
repairing.
Withdrawal 20.
Okay, got it.
Well, in this case, as per my instruction, certificate submitted in this case. no?
We sought for a report from the concerned IO whether the notice under section 47, 48 served on.
Notice was served, Lordship, but they only ground of arrest. I have annexed in the petition.
Call for a readable scan copy. Okay, records of. GR number 285/2024 arising out of BP police station case number, sorry, BP police station case number 0101/2024. In which Tarset was submitted on 30/04/2025 by charge sheet number 20/2025 from the Court of Learned Special Judge NDPS from Session Judge Party on the cook. List on 12th of June.
Can it be on 11, Lordship?
You want on 11? You try 11.
Lordship, much obliged, your Lord. Much obliged.
Copy registered petition.
Right, also, my idea was also rejected, my lord, on 4/3/25, page 98. Well, thereafter, not a single witness has been examined, madam. After there is no development at all, madam. Out of 56,
Only 19.
only 19, my lord.
Is in custody since when?
Since, my lord, 4/9/22, in other case, he got, my lord, acquitted. Or not acquitted, on a conviction, and because of the underground, he had already done that.
Mr. Bhattakur, what is this? Why prosecution is not reducing evidence? Even in such serious cases?
Present status report, along with, maybe also.
Since 4/3/25, not a single.
Will have it.
Last witness at the meeting October 24.
Yes.
Up to 97.
Petitioner, such and such and such. Mr. H.R. Chaudhary, Learned Student Council, assisted by Mr. A. Mahmood, Council appearing for the petition. Also heard Mr. P. Bhattakur, Learned Student Council, hearing. It is submitted that the petitioner such and such was arrested on 12/09/2022 in Barpeta Police Station, case number 763/2022. That's it. Case number 3. After filing of the charge sheet in the same case. It forfeited. So the registered assistance case number such and such. And charged under section 18/19/20. Under the unlawful activity during the Prevention Act 1967. Framed on 20/07/2022. accepting the petition, other accused persons of the case has already been released on bail. It is submitted that as on 10/03/2025, out of 36 named,
My lord, exactly third, it is 56, my lord, this is still
5/6,
5/6, my lord.
As per source.
5/6
Those are
named
listed
prosecution
with this
witnesses.
one.
Yes,
Those may not be required, madam, to take up all those.
no, 56.
The
was-
prosecution has adduced evidence of 19 witnesses. Before the learned trial gets admitted, who were thoroughly prosecuted. Mr. Chaudhary, learned senior counsel appearing for the petition, submitted that the earlier bail application of the petition being bill application number 100 of 2024 was rejected by the court on 04/03/2022. Though the case was fixed on 10/03/2025 for recording of evidence of other proceedings. Since 10/3/2025, the prosecution did not produce any of its witnesses to record it. Hence this bill application. The investigating officer of Forfeiture Police Station case number such and such. Investigating the Superintendent of Police of Forfeiture District shall apprise the court of the present status of this case number 10 of 2023 arising out of Borpeta PS case number 763 of 2022 and the number of witnesses so far reduced by the prosecution, giving the dates on which they were produced. List of copy of the list of 10th of June. Copy of this order be punished, Mr. B. Water.
My lord, your lordship is of 10.
Well, report has to be come from, madam.
Session judge, Borpeta.
SP Borpet.
Not, it is pending before the court, man.
Matter is pending before the trial.
Session judge.
No, we are asking the prosecution. We're not asking the,
No, procedure, all records are there man, in the court, man.
in addition to the above. The learned session that Borpeta shall also give the date on which the matter was fixed for recording of evidence of prosecution. Comma 1 to 2. The dates on which prosecution had its evidence and the presence of the prosecution. We have this one.
Might be your lordship, man. Here is a case, my lord, yesterday, your lordship, 23 petition before your lordship. Some incident took place somewhere else, my lord, and these people have been apprehended because some allegation is that, my lord, they have assaulted the police, man. And
What is the stage now?
and people from the almost same family, etc., my lord, from a different village, man, different place of occurrence.
Investigation stage now.
66 years, 60 years, my lord, ages there also, my lord. Told them, my lord, it is just name rivals, village rivals, they have to put their names, right? And it is not possible, my lord, so many hundreds of people were there.
Get a case diary. Yes,
Short date might have only by
Dolgaon, Dorong, give us the date, Mr.
Yes, on my lord, 9th of June. Ninth of.
my lord, can it be before Eid, my lord? Can it
Don't
prior
have
to
it.
6, my lord?
What will happen on the same date? We have to again ask for dates. You will not get it. Mr. Potago, if you can give it, fine.
5, my.
Six.
On the 6th, there may be holiday because of Eid, my lord, that 5, can it be on 5?
Ask Mr. Potago if
Yes.
you can produce.
Not a
it.
he'll consider.
I will try, but my lord, it will be difficult.
Let us try on the 5th, my.
If you, it's up to Potago.
5, my lord, yes. God bless you.
24th arrested, 14, 15 gambling, one, the personal mobile and the cash amount 25,000
Yes,
seized.
today is 28. Mr. Potago from Potasilam, but give us a date.
6 June, 6.
Maybe on 5th, my lord.
It's only up to Potago. We don't know.
Yes.
It's where Potago, team can give the date. If you do not get it, we'll have to give another date.
Yes.
It's
5,
up to
6.
you.
5, 6, my lord. Yes, it.
As because Mr. Up to you.
Yes.
If you can produce it, fine. If you cannot, you have to.
Yes. Oh, 5, 6.
Yes.
Not FIR is a press. 10, lord.
Yes, from Abhayapuri.
From where on 9th of June.
Can it be on 10th, lord?
Yes, on 10th of June.
Okay.
May I please, your lordship? Okay. In this case, lordship, the FIR is page number 17, lordship. This is registered under section 13(1) of Cattle Preservation Act, lordship. The petitioner before your lordship is the owner of the cattle, lordship. And lordship, the learned court below has already granted Zimma of the cattle to the petitioner.
Take it. You just found it. Nothing. Yes, get a report.
Yes, sir.
Get a report. From Dhubri.
On 11th of June,
Okay, fine.
highly applied.
May I please your lordship, BNS bail application lordship, section involved is 85 BNS and 82 lordship. Lordship, that allegation is in respect of offense lordship, last committed on 16/8/2020. Now after lordship, 6 years they have lost the FIR, even it is not also maintainable lordship. After coming into BNS, this offense, FIR has to be registered under IPC 498 lordship. So lordship, next is page 11 lordship. Not a single whisper of demand of dowry lordship. The section has to be put under IPC lordship, as per the lordship checking clause. Under Article 23 of the Constitution of India, the offence were under the committed under the IPC lordship, because all offences are prior to 1/7/2024 law. The last separation there is 16/8/2020. That was prior to 2023. And the alleged marriage was committed happened on 6/4/2015. That too prior to lordship 2023 lordship. So that BNS section cannot be applicable in this case, even though lordship, I'm ready to cooperate lordship, but I'm protected lordship in the meantime.
Good, sir. Mr. Protocol.
Procedural mistake can be rectified, my lord.
How can you
Otherwise, he has,
rectify this procedural mistake, one putting the FIR, say, third submission?
Part Mr.
he has committed the offense.
P. Doctor. Council appearing for the particular. And Mr. People. They will send you a call now.
Lordship, no lordship, that Panjal Datta lordship, who could not come to this court lordship. He has engaged me to the. He has in this court of.
Yes, when?
Allowed on 11th of June.
Prepare before CIO.
That's it. Hello, in case of granting interim, my lord, on 17th of June.
Too late. 13th of June.
Yes, sir.
Prepare before the IO on or before court.
That's it.
42.
Of like that.
May I please, your lordship? Lordship, in this case, my lord, the petitioner before your lordship is an advocate, my lord, and a notary, my lord. In this case, my lord, the one daughter has shown one false affidavit. Thereafter, the father has lost this FIR, my lord, against the daughter. My lord. My lord, in this case, the daughter, I have annexed the affidavit, my lord, has stated in his, that is at page 12, 14, my lord. Lordship will find the affidavit at page 14, that father died, some legal heirs are there, stating that affidavit, the daughter has shown this affidavit. Thereafter, she has manipulated some land documents, my lord. I am a notary, my lord. I cannot go into the fact whether a person who is swearing in affidavit, my lord, whether the statements are correct or not, my lord. So I am no way connected in this case, my lord. And that affidavit has been also been identified by one Rahimuddin advocate, my lord.
Where is your signature in the affidavit?
My lord, not in the affidavit, my notary seal is there, my lord. In the page 13, my lord. Page which is Singa, my lord. Then seal and signature is there, my lord. Then again, in the page 14, my lord, notary seal and signature is there, my lord. Advocate seal and signature also there, my lord, just below the signature.
Report. Yes, when on 12 of June, 12 to 15. Section. You can take. Unauthorized. An affidavit. Shown by
Rahimuddin, my lord. Advocate.
here. Letter on 13. Right. Appear before the IO, on or before.
Lordship, deplorable.
Please carry, what is it on? 70?
Yes, sir. All of them.
This is the third bail application.
Switch on the microphone.
This is the third pre-arrest bail application.
Earlier rejected, earlier rejected by this court.
Yes.
Petty case there,
Yes.
well,
On my lord.
Bongaigaon.
10th of June.
May it please, your Honor. In this matter, we have come challenging the transaction of the Jimma of the cash amount of the petitioner, your Lord. Here, report to him. Here, your lordship, there was no allegations from anyone that there was any theft or something. Only it was seized. Your lordship, what has happened? In this case, two items were seized, cash and gold. With regard to the gold, already this honorable court has granted the Jimma by this order. And your lordship, that order, your lordship will find at page.
I have received the report.
Lordship will kindly take up page 65. Because both the items were seized, and in that one item was already granted Jimma by this honorable court. Your lordship will kindly take up page 65. Report on Dilan. Dilokha.
Regarding the cash amount, my lord, I will, because that is only regarding, my lord, gold. That report is.
No, gold to already Jimma has been granted. Lordship will kindly take up page 65. I am saying that because in the.
Pardon, Mr. Permanent Counsel appearing for the petition. and Mr. P. Botlaku. In STPPS case number 07/2023. Registered section 379/411 IPC. Being specific. Epoch. Case amount of 22,70,000. Was recovered. From the Hyundai 120 car. How much? Gold, 585 grams of gold. The, as per the report of the concerned investigating officer of STP case number 07/2023. Search it. The said case was already submitted on 21/03/2024 by charge sheet number 01 of the 202. It is submitted in that Jimma of gold weighing 585 grams seized in the case has already been given. By Jimma number 05/2025, dated 21/03/2025. On executing a bond of rupees 3 lakhs. However, the Jimma for the case amount of rupees such and such in lakhs has been rejected by the Court of Learning. Additional Chief Judicial Magistrate Kamruk Metro Guwahati in PR C number 758/2024 on 05/05/2025. Next. In the report submitted by the investigating officer of said STPPS case number such and such, dated 26/05/2025, placed before the court. There is no indication regarding the recurring as to whether Jimma of said cash amount of rupees 22,70,000 as required during the trial or not. Call for a first report in that regard from the concerned investigating officer of STFPF case number 7. Also call for the eligible scan copy of the PRC number 75 of the 2024, along with the petitions filed by the petitioner regarding Jingama of the cash amount seized in the case that were rejected earlier on 10/7/2024, 30/7/2024, and 05/05/2024.
My lord, I would like to point out one thing, my lord, regarding the Zimma of the gold, that was a separate criminal petition, that was already disposed of.
That you know.
In
that
that
We
petition,
want
in-
it whether cash is required
Oh,
for
yes,
during the trial. or
this
cash
is the, in the present case only regarding the my lord,
Cash.
cash amount.
yes,
Yes.
this is only with regard to cash.
Cash.
Yes.
And then in the earlier
You
order
wanted
also,
a report only for the cash, not for
Yes,
the.
yes, my lord, yes.
and in fact, in the order itself, it was stated that the cash amount belongs to.
16th of June. Registered, POC petitioner from the court of eligible can copy of the from the court of learned additions of the registers. Already. Take back your report, get a fresh.
Yes,
report.
sir.
Maybe you'll see. Malad, I am praying for quashing of Malad CR case. Down to Malad, FI police station case, Malad, case is case 10, Malad, connection 1. Here in this case, Malad, complainant initially Malad married petitioner Malad, and after a few years, she denied to have married the petitioner. And thereafter, with a concocted story, my lord, lodged this FIR. Though, my lord, immediately thereafter, she also approached before the police, my lord, not to pursue the case, my lord. Even thereafter, my lord, because of non-bailable section already,
So Lordship, matter may kindly come on next week, Lordship. In meantime, filing or Bakalatam.
What's your good name?
SR Majab here.
Heard Mr. A.M. being considered for the petition. And Mr. P. Bothaku, the Regional Public Hospital of the state. Respondent number 1. During the deliberation of the matter, MS. M.R. Mazhar Bhuyan,
SR Majab.
S.R. Learned Counsel. On instruction of the complainant, respondent number 2. Very in the matter. And face for some time. Profile. Careful from that. Prayer allowed. Yes. 9th of June. 9th of June.
Malad. Oblige.
May it please your lordship. Lordship, learned counsel AK Bhuyan is on legs. Kindly pass over the minute of timing.
What is the next date?
Lordship,
What is the next date?
so next date. Lordship, not aware, Lordship.
What is the order of NBWA?
Lordship.
Five, 20,000. Page 48, my lord, last order passed on 13/3/25. On that day also available warrant of arrest issued and fixing 5/5/25 for appearance thereafter, my lord.
You appear, we'll give you protection.
Lordship,
You appear, we'll give you protection. That's all.
Lordship, my senior perhaps has something to say.
Friday.
Yeah.
Yes, next.
Lordship, in the last matter, we will take the interim protection, Lordship. In item 12, Your Lordship,
Yes,
about the interim.
you appear, then we'll give you protection. You will not appear, we'll not give you protection.
Lordship.
Friday.
Very please, Your Lordship. You said, petition fine. Challenging the order date 27/6/2024. Thereby, my Zimmer petition filed by the petitioner rejected now. But earlier also petition approached my lord, this honorable court by filing petition 130/2023, my lord. Challenging the order date 19/10/2022. Honorable court has adopted it is page 40. Page 39, is page 39, my lord. I wrote 8/8/2023. Dispose of the said my lord criminal petition. Granting levity of the petitioner to approach the learned trial, learned court below with a fresh petition, and the learned court below will dispose of the same in the light of the guidelines laid down by the Honorable Appeals Court in Sunderbhai Ambalal Desai of the state of Gujarat, my lord. Thereafter, the petition filed a petition, my lord, with reference in accordance with the direction given by the Honorable Court. That is page my lord 49. Seeking custody of the seized my lord documents and mobile phones that were seized by the police on 7/7/2022 and 15/7/2022, which is page 30 and page 33, my lord. Though the case was registered in the year 2022, as of now, the police did not file any charge sheet, my lord. Has not been filed any charge sheet. Without filing charge sheet, my lord, the submitting article in the police report saying that, my lord, release of the my lord seized article it adversely affect the investigation. So the FIR is concerned, my lord, the petitioner has not, listener name has not been figured in the FIR. Simply during the course of investigation, my lord, through mobile taking of one of the co-accused, my lord, who is actively involved in the alleged offense, petitioner has been apprehended. Subsequently, he was released on
Then
bail.
what happened? After this, the order of the court,
Yes, my then my lord filed an application, my lord, that is page K, my lord. There, my lord, page 54 impugn order.
what is the stage of the proceeding now?
You see, the police said that it is, my lord, consequent, my lord, a conjugative report
containing the same thing, my lord, saying that still there are some co-accused who are yet to be arrested, my lord. And the release of this, my lord, particular documents at this stage would adversely affect the investigation in the three police reports that I submitted, my lord, that I annexed to page 56, 57, 58, my lord.
Mr. Bhattakur.
Yes,
go- Get the case record along with the report of the IO.
yes, sir.
When? This has to come from Sonari.
Sonari, yes, my lord. My lord. 19th of June, my lord.
Okay. Placed on 19th. And I will Mr. P. Bhattakur to relation public prosecutor. So place the accurate case diary of Sonari PS Police Station case number 106 of 2022. Under section 120B, public 121, public 121A, public 387 IPC. Reduce section 10 of 30 of the Unlawful Activities Prevention Act. Along with the report of the concerned investigating officer, section IPS case number 666. Pertaining to the Jimma of the seized articles. Seized on which date?
On seven, then you'll find page 30 on 7/7/2022. And page 33. 15/7/2022.
Seized on 30, no,
7/7/2000
07072022
and 15/7, page 33.
and 150720. Which actual one. Seized in the case, seized in the case on 13th. So it's actually. Copy of this order to Mr. Bhatt. Give me an extra copy.
Man. All right.
Better fella for this from my.
May please, your lordship.
Lordship, this is 528 BNS application lordship for quashing FIR lordship. But at this stage, my lord, my limited prayer, the notice may be goes to the respondent number 2 lordship. And the petitioner is a retired army lordship, and he got retired in the year of, in the month of October.
The. That's one number one. That's one number two. Oh, it's- On. Zero 9012025. Laws and affair. Before the Bhopal police station. Begin with the petitioner. Committing rape. On her. Daughter. Who is a specially able person. Person to which OPS case number 16 of 2025 under section 64 in bracket 2 in bracket K. BNS. Register again. Corresponding. Case number. Corresponding to GL number 15 in bracket K. 2024. Register again. Petitioner has filed this application in the section 528 VNSS. For person of proceeding in the same OPS case number such and such, as well as the FIR dated such and such, lost by judgment. Issue notice, return in July 19th of June. As such and such, names petitioner subject state for subsequent. Very good to know. Body of parity.
Deeply obliged, Lordship. Obliged.
May it please, Your Lordship. In this case, I am ready to appear, Your Lordship, some protection, Your Lordship. The next date is on 24/7/2025, Your Lordship. We are shown as absconders, Your Lordship, in this case.
In a complete case, loss value also is starting in the code. Being. Test number 109 CR 2014. All the report of minutes are being made with the would the petitioners and then make you under section 366 within the detail of the 354 within the detail of the 376 of the I1 IPC. The said complaint gets as by the Custodial police station case number 75 of the 2014. Under section 366, in the A, 85 in the A, of 376 of the 511 by PC. Corresponding to GR number 312 of the 2012. After recording of the victim, the completion of the investigation. Search it inside by Custodial police station case number was essential. Submitted on 28/05/2024, 28/05/2014. White charge sheet number 70 of the 2014. Under section 366A, public 354A, public 376, 511 IPC against the board the petitioners. Stating that they evaded arrest and did not appear before the concerned investigating officer during the investigation of the case. And found them to be absconders. The photo planets. Judicial Magistrate First Class Inside GR case number 314/2014. On 17/7/2015. To cognizance of the offences under section 366 in bracket A, oblique 354 in bracket A, 376. Oblique 511 IPC. Against the petitioner. And issued summons to them. For their appearance. Due to non-appearance of the petitioners during the appearance date itself. The learned JMFC, Rangia Kamruk, inside their case number such and such. Issued order of non-billable warrant of arrest on
Page 45, Your Lordship.
Twenty-two 05/2017. Prior to that, the Lunatic National this is order of BWA. Billable for the appearance of petition. As the petitioners did not appear before the court of London, then it's secret. On various dates. The learned magistrate. Inside GR case number 314/2001. Issued the orders of NBWA. Against the petitioners. For their appearance. The matter is still pending at the appearance phase of the petitioners. And the same GR case. Mr. Gabriel and counsel is hearing for the petitioner's trouble. That. Next date of said GR case number 314/2014. Next, same date is now fixed, GR case is now fixed on 21st of June
24, Your Lordship, 24 July 2025.
for appearance of the petition. It is submitted, they have the petitioner that they are willing to appear to the report of London such. Okay. However, they are appearing that the issuance of the orders of the PWA and NBWA that are enforced. They will be appearing in custody on their appeal. 11th of June, we appear before the court of London JMFC again.
Much obliged. Right.
I'm sorry, my lord, may I take the leave, my lord? Item number 12, my lord.
We are
Here-
picking Friday because
My lord, Friday I will be out of, there is urgency because warrant of arrest has been
that
issued.
is the reason. We,
My lord, absolutely simple
appear-
case and been, no, my lord, here is a case wherein we have, my lord, come for quashing of the whole proceeding on a law point, which is decided by this honorable court. Time and again, there's judgment to do that. My lord, here happens, kindly come to the complaint itself, my lord. It will take, my lord, just 1 minute to make it, my lord.
there are still-
Yes, page 13A, my lord, will kindly see. Now here, my lord, DY 365 is been made an accused number 1. Managing director is before this honorable court. Managing director name is not there. Editor in chief and one Ratul Borgohain. These are the 4 accused person that has been named. Now, whole of the complaint, there is no avertment that looking after the day-to-day affairs. Press and Registration Act, my lord, is very clear. My lord, vicarious liability doesn't come into that judgment, my lord. Criminal petition 556 of 2012, paragraph 7, my lord, will kindly come to. These were my submissions been made. That, my lord, the company has to be an accused in this case. First thing, company is not an accused, first of all. Second, my lord, vicarious liability of the managing director doesn't come into in a criminal case, my lord, when there is a special act, Praise and Registration Act, paragraph 7, my lord, will kindly see. One of the contention made on behalf of the petitioner is that alleged defamatory items is stated to be broadcast through a television channel DY 317/6/2012. The accused number 1 has been mentioned as executive editor, so-and-so, Mrs. Brahmputra Teleproductions, Private Guwahati, and the accused number 2 has been projected as the reporter, so-and-so. It is contended that as defamatory item was broadcasted through the television channel DY 360, the criminal prosecution against the accused persons herein are not maintainable in absence of the company Brahmputra Teleproduction Private Limited, which owns, runs, and operates the television channels DY as an accused in the present complaint. It is also submitted that there is no avertment and material placed before the Honorable Court so as to foist criminal liability against the accused person, as the complaint is not clear how the accused person will respond for broadcasting of the alleged defamatory news article. My lord, will kindly come to now paragraph 120, my lord, my lord, 12.1. These are the laws. Managing director cannot come into, my lord. 12.1, appellant number 1 is the managing director of the company, respondent number 3, and its general manager. Indisputably, company is a juristic person. The demand drafts were issued in the name of a company. The company was not made an accused. The dealership agreement was by and between Akash and so. 12.2, my lord, this is another Supreme Court judgment, my lord. Whereas jurisdiction is exercised on a complaint petition filed under section 156(3) or section 200 of the Code of Criminal Procedure, the magistrate is required to apply its mind. Indian Penal Code does not contain any provision for attaching vicarious liability on the part of the managing director or the director of the company when accused is the company. So here accused is not a company, my lord. The company itself is not an accused, and even director has been made an accused, my lord. And I have, and ultimately, my lord, will kindly come to the finding, my lord. Set aside, my lord. And the findings, my lord, paragraph 14, my lord, will kindly see. This is a court finding of this honorable court, my lord. Appreciating the Supreme Court judgment. Reverting back to the case in hand, for fostering criminal liability, there is no presumption that every employee in the broadcasting company knows about the broadcasting. There is no accusation that either of the two accused persons directly used any defamatory words. It is not averred in the complaint that it was accused number 2 who had provided the alleged defamatory items to the television channel DY 365. The accused number 2 has been alleged showing him to be a reporter for the television channel DY and a resident of the area of jurisdiction of the learned trial court. Bold assertion that he is a reporter for the television channel so and is a resident within the area of jurisdiction of the trial court are not sufficient to force criminal liability on a person without any further material to show as to how he was directly involved and responsible in the commission of the alleged offense. On the other hand, the accused number 1 has been assigned showing him to be an executive editor for the news channel, a television channel. The role and function of executive editor in a television channel is not explained by the complainant. The complainant has not pleaded and explained as to how accused number 2 had played any role in choosing the alleged defamatory items with prior to its broadcast on 17/6. There is no specific allegation against the accused persons that all the requisite knowledge as regard to broadcasting of the alleged defamatory news item, or that they were directly responsible for broadcasting of such defamatory news item, and they were in charge and conduct the affairs of the news television channel DY 360 on the date of commission of the alleged offense. There is nothing else, any prior concert and any joint participation statutory which automatically fasten criminal liability on executive director, editor, and a reporter of a television channel who is broadcasting news item. Yes. So that has been the law and it was quashed, my lord. Here, when the company itself is not made an accused.
Agreed by the order. Agreed cognizance. 1911-2001. In clear case number 78 of the 2009. By the London division makes a plus the global value. The something brought by the that's one number 2. The orders of
Available warrant of arrest against the petitioner, as well as the order of non-release warrant of arrest against her in same circumstances. The petitioner has filed this criminal petition in the section. Quashing the proceeding of share based number against her. Mr. Mayor and council appearing for the petition. Something. That the petitioner is the managing director of Brahmaputra Tele Products Private Limited. Where TV channel DY365 is an unit on the feature. Placing the complete petition of said seeker, surface number 75 of 2019. It's a one to this petition. File with number US complaint on 0409. Before the safety division registered at the government. An accident. Mr. Mayor submitted. Mayor CXP. That Brahmaputra Dairy Products Private Limited is not an accused in said case. And as such, taking cognizance of any such offense against the petitioner, managing director of Brahmaputra Dairy Products Private Limited. Under 2000.
Page 39 is the order of taking cognizance, my lord.
Cognizance of the offense. That's some 500 or 34 silence. It's bad. In that regard, Mr. Mayor. Consider paying for the petition. Relied on the situation. Reporting advance of this book. In the case of Pranay borderable persons and another versus state of Assam and another. Decided on 09-620 in criminal petition for 556 of the criminal. Like in various decisions of the honorable. The notice. By 24th of June. As Mr. Potato and its prosecutor excellent.
petitioner submits steps for service of petition response. Right. Subject to taking steps on the respondents and direct. The proceeding of sale. Say our case. 78. For the CDP of 001. Against the petition. Pending before the court of law. Judicial magistrate plus plus. Approval. Salary.
I'm deeply obliged, my lord. And when I wish my lord is transferred to Bhubaneswar and Lord be, my lord, this would, my lord, yes, which is this honorable court to carry the good one. Jagannath, my lord, will bless. I take the leave, my lord. Maybe the last case I am doing before your lordship, this one. My
That's
lord.
it, that's it.
Please, your lordship. 17. Thank you. My lord, I guess council is in another court. Matter may be taken after some time.
No, this matter may kindly taken up some other day, my lord. I will have to also go to, or after some time, my lord, I will also have to go through the.
What's the, some other day?
Yes, ma'am.
Hard for it.
Like,
Yeah, I believe it. My lord, here in this case, my lord, already 8 prosecution witness has been examined, my lord. And my lord, there is no chance of tampering or tampering. My lord. My lord, at this stage, I am not on merit, my lord. My lord, the main vital witness, my lord, prosecution witness has already been examined.
One report was called for, my lord. Your last, your lordship last order. Is it?
Scan. And my lord, the notice under section 50, my lord. Perhaps, my lord, I am not annexing, my lord. It is on record, my lord. The report from
The report.
Yes, you're appearing.
Yes, Your Honor, I'm for responding number people.
My lord, he is behind the bar, my lord, in jail more than 2 years, my lord. And my lord, in between, my lord, all the, my lord, vital prosecution witnesses have already been examined, including the victim, informant. And my lord, whether the custodial detention is required or not, my lord, only that point, my lord. Already, my lord, everything he has done, my lord. So, my lord, my humble prayer, my lord, at this stage, my lord, they may be allowed to go on bail.
Heard Mr. Assignment Counsel appearing for the petitioner and Mr. P. Thakur, an additional public prosecutor appearing for the state. What's your good name, ma'am? You are appearing?
Yes,
Heard Mr. Assignment Counsel appearing
Yeah,
for the informant. For the response number 2, informant, mother of the minor victim. As for the FIR, dated 27/04/2023. Laws before Procedural Police Station. The case is that the accused petitioners covered. When the minor daughter of the informant on 26/04/2023, after attending the school, went to her uncle's house to have lunch. Went to have and had lunch. While returning home from her uncle's house, the accused petitioners induced her and took away the pill where both of them raped her. as thereafter, what the accused petitioners brought the victim girl to the road, left her there alone, and fled away from the scene. Said FIR of the informant respondent number 2 was accordingly registered as Sotavadi Police Station case number 80/2023 under section 376. Within bracket EA IPC, read with section 6 of the POCSO. The petition is submitted that since 27/04/2023 they are in custody, and in the meanwhile, all the vital witnesses have been examined by the concerned trial court, including the victim girl. And as such, further custodial detention, as such, their further custodial detentions are not warranted. And they said, such a this case. Where was the case record of special POCSO case number 129/2023, along with the records of Sotavadi PS case number 80/2023 that were called for by order dated 17/03/2025. From the records of the case, it is seen that during investigation of the case, the statement of the minor victim girl under section 164 CRPC was recorded by the learned Judicial Magistrate First Class Borpeta on 27/04/2023, in which she implicated the petitions. During investigation, police seized the birth certificate of the minor victim girl. Issued by the Registrar of Attendance, Surrogate Republic Health Center on 10/02/2009. Issued by registration number 59/2009, indicating the date of birth of the victim girl as 23/01/2020. Considering the birth certificate of the victim girl, her age on the date of the incident on (26/04/2023). Found to be only 14 years, 3 months. The petitioners, in the meanwhile, were arrested on 27/04/2023. After completion of the investigation of the case, police Saraswati and State Sotavadi PS case number 80/2023 was submitted. on 20-09-2023 by charge sheet number 98 in bucket B of it 2023. Under section 376 DA within bracket IPC in section 6 of the POCSO Act against the petition was. Charge under section six of the POCSO Act is framed against the petitioners on 30-08-2023. Next step. From the records of the case, it is also seen that out of the 9 named prosecution witnesses, prosecution has adduced evidence of 8 of its witnesses who were thoroughly cross-examined by the defense on behalf of the accused persons. It is seen that the evidence of the investigating officer of the case is yet to be recorded. Next. Considering the above, the court is of the opinion that the rights of the petitioners daily on such and such not been infringed. As such, detention of the petitioners since 27-04-2023 in said special POCSO case number 129 of 2023 arising out of such a very police station case number such and such pending before the court of London special judge POCSO Borpeta comeditional session judge cannot be considered at stage according stands with that. From the charge sheet of the case, it is seen that the accused petitioner number 1 was of 28 years. The accused petitioner number 2 was of 22 years. At the time of filing charge sheet on 20-09-2023, where the victim girl was of only 14 years of age in the date of the incident. It's not on merits. That's rejected. We'll come back at 2. . . 2 . 2 . 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. 2. No representation on behalf of the petitioner on call, even in the first one. The matter was taken into consideration. Petitioner remained unrepresented, placed after a week. Yes, Mr. Hussain, what's the matter about?
My lord, regarding the NDPS, my lord. My lord, my name is not in the FIR. Nothing has been seized from me, my lord. Only I was arrested by alleging that co-accused mentioned my name. Only that much, my lord. Subsequently, 6 witnesses, my lord, are examined, including the informant, my lord. No witnesses, my lord,
Implicated
implicated
you.
my name, my lord. Yes, my lord. Lordship may
What is the name of the accused?
page, my lord. My lord, only
Name of the accused.
name of the accused, my lord, Mohibul Ali, my lord. Mohibul Haq. Not in the FIR, my lord. FIR
Mohibul Ali, Rahul Ali.
My lord, my name is not Rahul, but another Akash Ali alias Rahul. But just to drag me in the my lord case,
What about the father's name?
my lord, Rahmat Ali, my lord,
You are son of Rahmat Ali.
my lord.
And no.
In the FIR, my lord, my name is nickname written as Mohibul Haq alias Rahul. My name is not Rahul, but another accused was my lord. He is Akash Ali alias Rahul. When I was arrested, my lord, just to if lordship peruse the forwarding report, my lord, all allegations regarding the accused number, my lord, arrested accused persons narrated in the forwarding report, and my name is only written as Mohibulak alias Rahul. Lordship may peruse page, my lord, FIR page 11, my lord. On day itself, in the FIR, 6th line, madam, from next, my lord, forwarding report and seizure list, my lord. Everything is from seizure list, page 22, my lord. And already seizing witness those, my lord, Fiddus Ali, Rafiqul Islam already examined, my lord. No one implicated my name. I am not there. Even informant also not mentioned, not implicated my name in the evidence, my lord. In the charge sheet also, my lord, only name was Akash Ali, my lord, mentioned, and subsequently only my name is included. Nothing allegation given against me that so and so. In the charge sheet, my lord, page 35, my lord.
Right. Pardon, Mr. M. Hussain, counsel appearing for the petitioner. And Mr. Election and Review. Special independent NDPS case number charge and arising out of WPS case number. Arising out of Goripur PS case number such and such. Corresponding to GR number 1112 As for the affair. Dated 13/06/2023. Lost before the Goripur police station. 80706. On receipt of reliable information. The evening on 29/06/2023. That one Akas Ali alias Rahul, son of Abdul Samad, is carrying NDPS substances near Modhu Solmari
Part one.
railway part one railway crossing gate. Police personnel from Goripur police station with due authorization proceeded to Modhu Solmari, Goi Bazaar, near the railway gate. In presence of local independent public / villagers. Said Akas Ali, son of Abdul Samad, was apprehended and on being searched, 1.87 numbers of 5 on PYVOON space SPASH plus tablet, comma. Recover 1.87 now, 87 numbers. 5 on 13. 1, 2, 3, 4 minute, 187 numbers. 2, 30 numbers of nitron tablets, nitron 10 tablets. 3, 12 numbers of codeine based cough syrup. Along with his Redmi mobile phone, Indian currencies and Bhutan currencies. Those recovered items from the conscious possession of said Akas Ali, the seized, was produced before the Goripur police station and arrested on 30/07/2023. Accordingly, Goripur PS case number 257/2023 under section 22 in bracket small b /22 in bracket capital C NDPS Act 85 was registered. The petition said Akas Ali was produced before the Court of Lanad Chief Judicial Magistrate Dhubri on 01/07/2022. During investigation of the case, the petitioner is also arrested as he used to buy such NDPS products from said arrested accused Akas Ali and used to sell it within Modhu Solmari Motu Kulmari and Roa area under the jurisdiction of Boripur Police Station. For his arrest, the petitioner was produced before the Learned Chief Judicial Magistrate on 04/07/2023. And since then, he is in custody. It is contended by the petitioner that he is no way connected with the case. And the witnesses, prosecution witnesses so far examined during the trial of the case did not implicate him of committing any such offense as alleged. As such, considering his detentions in 04/07/2023 in say Goripur PS case number such and such, presently pending in special NDPS case number 337/2023 before the Court of London Special Judge NDPS from additional session judge to agree for a trial such and such. Peruse the records of say special NDPS case number 337/2023 as well as the records of Goripur PS case number 257 only. The seized substance recovered in the case. As per the FSL report dated 06/10/2023. Gave positive test for tramadol with 48.5 mg 1240. Positive test for nitrazepam with 8.85 mg and positive test for codeine as codeine phosphate 169.9 mg. After completion of the investigation of the case, we submitted a search sheet in said Goripur PS case number 257/2023 on 29/11/2023 by charge sheet number 676/2023 against the petition and the other accused Akash Ali alias Rahul under sections 22 didn't get small v of it, 22 didn't get C, the NDPS Act 1982. After filing of the search sheet, the Goripur PS case is registered as special NDPS case. On 17/01/2024, charged under section 22, in bracket C of 29. Reference against the petitioner, the other accused of Kasari. In special NDPS case number 337. From the records of the case, it is seen that as on 15/02/2025. Out of 10 prosecution witnesses. Prosecution, named in the source, prosecution is adduced evidence of 6 of its witnesses. Who were thoroughly examined by the defense on behalf of the accused petitioners, including the present petition. Section E, X versus register. Considering the materials indicated, since the considering materials indicates records as charged in the case was filed on such and such. SARS were framed on such and such. And as on 15/02/2025. Prosecution has already adduced evidence of 6 of its witnesses out of 10 named in this article. And considering the law laid down by the Honorable Appeals Court in the case of X versus Rajasthan with the court is of the opinion that the right of the petitioner for early hearing has not been infringed for consideration of this privilege as such. The petitioner 47 arrest to be applicable Sarsi. Accordingly. Finding no merits in this bill of expense with the
No lesson.
Need feature lordship. The regular mail application. NDPS case lordship. My main ground is your lordship, no ground of arrest was furnished to me lordship. Notice under section 50 is lordship on page number 31. Page number 31 of my petition is the notice under section 50 and 32 is the arrestment.
That's why I would place one judgment, but the same police station, same content of the notice, let's say, being granted by this honorable court. Take your seat.
Heard Mr. B. Bora, counsel appearing for the petitioner. And Mr. Sachin Chaturani, public prosecutor appearing for the state. Petitioner named Sachin.
Also, I have placed one order also.
This application under section 483 VNSS. Praying for his way in special NDPS case number 43/2024. Arising out of Bazar Sira police station case number such and such. In which charge was framed on 01032025 under section 22 in bracket C, public 25 of the NDPS Act, who is in custody since
5/4/2024.
zero five zero four two zero two. The bail petition of the petitioner earlier. Bail petition of the petitioner in said Bazar Sira PS case number 69/2024. Being bail application number 3037/2024 was rejected by this court on 11/11/2024. This is petitioner's second clearance bail. On 04/04/2024 around 12:30 PM during Naka checking at Churaibari Watch Post of National Highway number 8, 10 numbers of cartons containing 160014 phosphate and tripolidine hydrochloride syrup, ASCAP bottles, ASKUF bottles from 16-wheeler dazzling white color, each a Pro 3019 model container body truck bearing registration number AS01QC 1076 driven by the petitioner was recovered, which were accordingly seized. The petitioner was apprehended and subsequently arrested in said Bazaripura PS case number 69/2024. The petitioner, after his arrest, produced before the Honorable Chief Judicial, the Learned Chief Judicial Magistrate at Karimganj, now Sri Bhumi, on 050720 05042024. Custody since. From the records of the case that was called for, it is seen that the FSL report dated 23072024 indicated the seized 1600 numbers of codeine, phosphate, and tripolidine hydrochloride syrup, S bottles. Seized from the conscious position of the petition gave positive test of codeine phosphate of 119 grams. Full stop. It is also seen from the records of the case that altogether 190.4 kgs of codeine phosphate was recovered from the possession of the petition. Search it. In the case of submitted inside but there is a case. On 31072024, by charge sheet number 105/2024 against the petition under sections 22 in bracket C of 25/29 of the NDPS. Charge in the case, charge under section such and such. In bracket C of 25 of the NDPS was obtained against the petitioner on 01032022. From the records of the case, it is seen the said special and after filing of the charge sheet in such and such, the same was registered as special and case number 43/2024. And the matter is pending before trial, the Court of Law and Special Judge NDPS. Session Judge Sri Bhumi at Karimganj. Petitioner contended that while arresting him on 0407, right?
Yes, sir. 04/04/2024.
04/04/2024. The concerned investigating officer of St. Lazarus PS case number such and such did not comply with the provision of section 50 and 50A of the Code of Criminal Procedure that was in force. Section 50 of the CRPC stipulates as follows. From the records of the case, Section 50 notice served upon the petitioner on the date of his arrest. Received by him on 05042024 and 04042024. Found to be as follows. My petitioner. On perusal of the said notice under section 50 CRPC issued by the concerned investigating officer of Bazar PS case number such and such. Doesn't contain any detailed particulars as been provided under section 50 of the CRPC, under which he has been detailed particulars of the offense is written, for which he has been arrested, he was arrested, and other grounds of his such arrest. Moreover, from the reading of the said notice under section 50 CRPC, it is also seen served on the petition by the concerned investigating officer of the case on the date of his arrest. It is also seen that he was not informed by the concerned investigating of the case that he was entitled to be released on bail and that he may arrange for sureties on that behalf. This vital information not been provided to the petitioner at the time of his arrest by the concerned investigating officer violated the right of the petitioner under Article 22 of the Constitution. Consequent, for such violation of the provisions of the Constitution, the rights guaranteed to the petitioner under Article 22 of the Constitution in the time of his arrest is entitled for this. It is also seen from the records of the case that No. Already. Already. 2 lakh. Condition with the.
Obliged lordship. Obliged.
The 52 year the cover.
Bora,
1 and 2 also. Sorry.
make please. Make please. Page 17, man.
8.
17, man.
Yes.
My lord, here I am appearing that serial number 1, my lord.
Hmm.
Now, lordship will go to the second page, next page, my lord. My lord, that, my lord, 5, 6 and 7, my lord. They were granted bail. My lord, 5 and 7, my lord, BA number 125825. And other one is BA 160625. On the last occasion, this case came up before your lordship, my lord, and lordship had called for the record was not available. That's why lordship had called the records of those 2 bail applications. And I have placed 2 orders of that bail, my lord. It was in the file. और कहाँ से है? अब्दुल्ला। Who accused that?
Yes. But Mr. Ranjit Rattal and counsel appearing for the petition.
Because in the present case, when the present petitioner was for grade envy. Present petitioner was for grade envy. Along with those, my lord, 9200 number for Yabba. So, my lord, the case of the present petition is not the same thing in respect to the other just one, because initially the present petitioner was for grade and thereafter on the basis of the present petitioner statements, other co-appeals were arrested. So, my lord, the case of the present petitioner is not in the same light along with other co-appeals persons. Secondly, my lord, in this case, my lord, present petitioner was arrested on 5/5/23. So, my lord, while my lord, other.
What about the other petitioners who have been already granted bail? Arrested when?
Those petitioners were also arrested, my lord. Some of the petitioners arrested on the same day, thereafter.
Same day, but
Same day, 5/5/23. On the basis of the present petitioner statement, my lord. Thereafter, police searched some of the laws and hotel thereafter other stated. And in this regard, I would like to submit before, while the petitioner, the present petitioner was.
See, in some of the cases, even this court have considered bail, and in some cases, this court have not considered bail.
Yes.
If in the notice is sufficient for the accused petitioner to understand why he has been arrested,
Yes,
definitely it will be considered.
Yes.
But if it is not sufficient, will not.
There are two, I would like to, from 2 other points, I'd like to about 2 other points, my lord. In case of while petitioner was, my lord, caught red-handed, in that case, my lord, I would like to rely on one judgment of the Honorable Supreme Court, my lord, 1969, reportedly 1969, 1 SCC, 292, my lord, Madhu Vimaya versus, my lord.
True, but why section 50 not subsequently amended the CRPC? What is the reason behind it?
Yeah.
Why? In Madhulima's case, something was raised, right?
My lord, earlier, my lord, Vidhan Kumar sir, every other judgment.
We are not on that.
You know.
We are not on that. In one of the judgment or orders passed by this court, we have considered a decision of a division bench of this court passed much earlier before the amendment of the CRPC. Justice Ali passed that judgment. King says this is the right of the accused to know. Now, Mr. Bhattakur, if you think that this is sufficient as per section 50, Burwa, so tell us, how do you have complied with section 50?
Yes, well, regarding that.
Kindly read. All cases are not alike. It depends upon the
Yes.
certain things.
So, my lord, as per the present, my lord, building law, after Dhyan Kumar, is not sufficient. But.
Why are you behind? What is section 50? Do you have the CRPC with you? On CRPC, do you have it?
দেখুন না।
Read section 50.
Yes.
What is the requirement?
Yes.
In certain cases, some reasons and grounds we can consider it.
To communicate, my lord, the ground.
Read section 50, the CRPC. There are two parts, 1 and 2. Read it.
Yes, ma'am. The 50, person arrested to be informed of the grounds of arrest and of right to bail. Every police officer, 51, police officer or other person.
Not required 51, you go to 50 first.
Yes, sir, yes. 50, my lord, that is person arrested to be informed of the grounds of arrest and of right to bail. That is, that every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offence for which he is arrested or other grounds for such arrest or other grounds for such. So in this case, my lord, by way of serving that notice, my lord, section 50 of the PRPC,
Full particulars of,
full particulars of the, my lord, offence,
put particulars of the offense.
yes, ma'am.
Okay,
Then this notice, my lord.
then read the next two.
Next,
52.
my lord. Where a police officer arrests without warrant any person other than a person accused of a non-bailable offence, he shall inform the person arrested that he is entitled to be released on bail and that he may arrange for sureties on his behalf. Here, my lord.
Now kindly read that notice.
Further intimated that you should arrange for sureties on behalf for release on bail.
Now, Mr. Bhattakur, kindly read the notice under section 50 issued to the petitioner.
Yes, sir. You are hereby informed of your arrest in connection with your below reference case circumstances. The case is bailable, / non-bailable to police. Case number and penal provision of law, reference and circumstances and PS, value PS case number 22 under section so of the NDPS. Thereafter, the second portion of it. Further intimated that you should arrange for sureties on behalf for release on bail. So, section as regards to the section, article 22(1) and 22(2) and section 52.
Section 50, subsection 2 complied with. What about section 50, subsection 1?
1, yes, and full particulars of the offence, then I will have to see whether arrest memo is.
You are supposed to do in section 50, not in arrest memo. Dhyan Kumar relates to arrest memo. Granting something in the arrest memo is not sufficient. You have to be doing 47.
There is not detailed particulars on.
Then give it to us. Heard Mr. Ranjit Rathore, counsel appearing for the petition. And Mr. P. Bhattakur, and additional public prosecutor appearing for the state. Petitioner namely self and such and such. File this application under section 483 BNSF. Praying for his bail in special.
NDPS case number 161 of 23.
NDPS case number 161. Why you are writing 76?
My lord.
Come to page number 1.
Oh, my. In my case, my lord, it was Whitener, it is corrected. my lord.
Here the post copy not corrected.
And I'll correct it, my lord. I put an initial, my lord.
Mr. Rathore,
One of these,
not by you.
my lord.
I can understand.
I do.
Not by you.
Your lordship may not consider, but I would like to put only one supposition, your lordship.
We would not have considered had there not be any violation of
Only
the
one point.
constitutional provision.
Not, yes, my lord, I understand, but only one point. That's because in this case, my lord, rate of arrest is 523. I just want to submit, my lord, because as per only.
You should read the Vihan Kumar and
Yes, yes, my lord.
you'll know why at that stage the court considered to release the accused. Mr. Thakur should be updated. Mr. Datta, correctly put.
Mal,
where you
mal,
said.
I apologize, Mal.
NDPS case number 161 of the 2023. Under section 22 in bracket C of the 29 of the NDPS Act. Arising out of the Jalukbari PS case number 269 of the 2023. Corresponding to GR number 3177 of the 2003. In which is in custody since 06/05/2003. It is submitted by the petitioner that along with him, accused persons Ibad Hussain, EBAAT. Alias MD Ibad IBAT Hussain. Son of Abdul Hussain. Next week, Abdul Adut ABDUL. Adut ADUT. Son of Asad Ali Haq. And Mistaul Haq. MSTLHAQ, son of Abdul Aziz. And 3 others were arrested. And all of them were produced before the Court of London Chief Judicial Magistrate Kamrup Metro Guwahati on 06/05/2023. It is also placed by Mr. Datta and counsel appearing for the petitioner that accused persons Ibad Hussain alias IBAT Hussain and Abdul Adut as well as Mustaqil Haq arrested along with him having granted bail by coordinate bench of this court by order dated 20/05/2025. First in bail application number 12582025 and bail application and order dated 22/05/2025. First in bail application number 1606/2022. Petitioner submitted that even in the case of even in his case, the concerned investigating officer did not comply with the provision of section 50 and 50A of the CRPC. Like the other co-accused, Ibad Hussain, alias Ibad Hussain, and such and such and such and such. For they were granted bail due to violation of the constitutional provisions. Mr. Botakur, learned additional public prosecutor submitted that the contraband goods, yani, Yava tablets recovered from the possession of the present petition. And as such, they should not be released on bail. As for the FIR, dated 06/05/2023. The case is that on the basis of a specific information and registering such information as GD entry in the Jalukbari police station, police personnel from the said police station with due authorization during Naka checking of AS 01 QC 2372 recovered a black and red bag from the possession of the petitioner and from the said bag in presence of the independent witnesses, 9,200 numbers of Yava tablets were recovered. As such, to make further inquiry, he was brought to the Jalukbari police station. During such inquiry, the police personnel from Jalukbari police station came to know that there are other people, other accused persons involved in the case. And the bosses of the FIR lodged Jalukbari police station case number 269/2023 under section 22 in bracket C/29 of the NDPS Act was registered. During investigation of the case, along with the petitioner, Abdul Haq, son of late Iman Ali, Muhammad Hamidul, son of Muhammad Apaba, Muhammad Nazir Hussain, son of Muhammad Hamidullah, Abdullah Adut, son of Asad Ali Haq, Mistaul Haq, son of Abdul Aziz, and Muhammad Ibad Hussain, son of Abdul Hussain, all were apprehended on 05/05/2023, and all of them were produced before the Court of Learned Chief Judicial Magistrate, Kamrup Metro Guwahati on 06/05/2023. After completion of the investigation of the case, police submitted the search sheet in said Jalukbari case niliki bar bhatto, after completion of the investigation. Police submitted a search sheet in Jalukbari case number 269/2023 on 06/05/2023 by charge sheet number
Man, the charge sheet number is not there,
Not there.
and its
Not there.
date is also not 6/5, man.
is 6/5 is there. Oh, it is not there.
Not there, man.
Just a minute, let's have the record.
Yes. At the top, my lord, scene, my lord, session judge, Kamrup Metro, my lord, 1610, my lord. That will be.
That's right.
Yes.
Samvijan 1610.
1610, my. My lord, there is a judgment, my lord, on the date, my lord, when the magistrate sees it, my lord, from that date, my lord, charge sheet, it should be counted.
That's right. Thereafter, says Jaluguri PS case registered as NDPS case number 161/2023. It is seen that charge under section 22, within bracket C, the NDPS Act was framed against the petitioner in said NDPS case number 161/2023 on So, 14/03/2024. However, yeah, according to section 50. Records of the case. The notice under section 50 CRPC issued by the concerned investigating officer to the accused petitioner during the time of his arrest on 06/05/05/2023 is as follows. Anyway. On perusal of the said notice under section 50 CRPC issued to the petitioner on 05/05/2023 while arresting him in Jalukbari PSK substance. Them is not found to be in conformity with provisions of such paragraph. Okay, did you? Do you last? Condition with the TV. Sorry,
I am obliged. My lord, if your lordship pleases, my lord, that 50 and 50A, my lord, not complied with. And moreover, my lord, section 52 of the NDPS, that is also not supplied.
Let it be here on this short point. Don't go for beyond that.
My lord.
Both can be taken together, my lord. In this case, my lord, I am seeking bail on two grounds. One, my lord, arrest procedure, and another is on ground of parity, because one was granted bail on ground of arrest procedure. In 33, my lord, page 53, 54, and 55 is the ground of arrest. And co-accused bail order, page 56.
Where is the forwarding?
Forwarding, my lord, forwarding, page 25.
Mr. Richard Chaudhary, counsel appearing for the petition. And Mr. P. Bota, for relation public prosecutor appearing for the state. Here is the completed page 53 in the petitioner namely. For this application and such paying for his bail. Special NDPS case number such and such, arranging of such and such. Under such and such in which he was arrested on 15/03/2024 and is in custody since then. The contention of the petitioner here is that a coordinated bench of this court have already released the co-accused Zia Uddin, son of late Ismail Ali, by order to 05/05/2025. First in bail application number 1403/2025. Arrested along with him in Karimganj PS case number 172/2024 for non-compliance of the provision of section 50 and 50A of the CRPC, being in violation of the provisions of the law laid down by the Honorable Supreme Court in the case of Praveen Purokastro and Rihan Kumar. Mr. Chaudhary, counsel appearing for the petitioner, submitted that even in his case, while arresting him in said Karimganj PS case number 172/2024 on 15/03/2024, the provision of section 50, the CRPC has not been followed. On those two grounds, one on the ground of parity, another on the ground of non-compliance of section 50 of the CRPC at the time of his arrest, the petition spread for his bail. Section 50 of the CRPC stipulates as follows. The notice and the whole sentence.
Page 5 is the.
Page 53,
Page
well,
5.
page 53 of the petition, well, notice and grounds of arrest under section 50 CRPC.
As per the FIR, dated 15/02/2024. The case is that on the receipt of specific information that two persons were carrying drugs in an auto rickshaw at Longai, Chandpur area for selling of illegal and psychotropic substances. After making necessary GD entry, police personnel from Karimganj police station arrived at Chandpur area and found the auto rickshaw bearing registration number AS 10C4665. During search of the said auto rickshaw, from the conscious position of one Setabuddin, son of late Murali, and Raju Uddin, son of Dr. Uddin, 53 bottles of trifluoride hydrochloride, 14-phosphate cough syrup were recovered. Rajuddin's requisition to the high petitioner also. During further investigation and interrogation of the accused persons, the police personnel from Karimganj police station came to know that huge consignment of drugs had been stored in the police reserve Dunitilla for destruction. And one Lansnack Ziauddin had stolen those cough syrups from the same police reserve and handed over to them. And accordingly said, Lansnack Ziauddin was also apprehended. The FSL report dated 22/07/2024. Right, FSL Sergeant of the seized substance recovered from the conscious possession of the petitioner gave positive test of codeine within bracket as codeine phosphate. The notice issued to the petitioner under section 50 CRPC the time of his arrest on 15/03/2023 is as follows. Is number 15. On perusal of the same, it is seen. Section 52. Court building. It is found that the same is not in conformity with the provisions of section 50 service as written in section 50. And thereby the right of the petition guaranteed under the provision article 22 of the Constitution on legal ground. As such, the other co-accused of the case was arrested along with the petition, namely such and such. Had already been released on bail for such non-compliance provision of section 50 CRPC. Notice you said in the section 50. Provision of notice on the fix. Considering their yeah. You are appearing in which set? Next item.
Next,
Item number
35. May I please?
Yes,
This is my lord's subsequent bail application earlier rejected by your lordship. And the new second application was filed on
Okay.
2 grounds, my lord.
He is Setabuddin, earlier your lordship, Rajuddin, and he is Setabuddin.
no, Satabuddin is the other case.
I don't know,
This is different case. This is item number 35.
35, Akum Chang.
Some video.
Your lordship rejection order is my lord page 47. The same date, my lord, he is,
Not Mr. Alhaji Namuddin, council, he would be council appearing to the petition. And Mr. He brought up petitioner namely such and such and such. Well, this application under section for it should be an assessed paying for his billion such and such. I think for BSS numbers such and such. Under section such and such. Corresponding to the number 335/2023. Presently pending before the Court of Law and Special Judge NDPS. The petitioner earlier approached this court for his bail inside special NDPS case number such and such. Where is the rejection order?
page 47.
Report by order is 19/12/2024. First in bail application number 3298/2024 rejected the case of the petition. This is petitioner's second bail application in said special NDPS case number, NDPS case number 23/2024. The contents of the petition that at the time of his arrest on such and such.
Page 61 notice, page 61.
Inside. Warpath Police Station case number 45/2024. Fifteen 11/2023. The investigating officer of the case did not comply with the provision of section 3 of the service.
Co-accused released by law trial court. Co-accused also released by trial court.
Where?
That order I have annexed.
Which?
Co-accused order 53. Procedure and parity on two grounds. Arrest procedure and parity.
It is also placed by Mr. Abdin Council appearing to the petition that the co-accused of the case, namely Sohaib Akhtar. No. What is his name?
Akum Chang,
Co-accused.
co-accused
MC Ongbo Chang.
Ambuk Chang,
ONGBOU. Chang CHND.
charge sheet also.
Has already been released by the Court of Law and Special Judge NDPS. Parveen Ground. The proof inside
Angbu,
Friday case number
8/5/2024.
08052025. Non-compliance with the provisions of section 50 CRPC. All done by the Honorable Apex Court in the case of Vihan Kumar versus State of Haryana Report of Principles. And Radhika Agarwal versus Union of India reported in 2025 SSC online SC 449. That relates to recovery of 1850 grams of 18.850 kgs of morphine from the spare tire of the vehicle during NACA checking. In which the petitioner along with said agent Mahan to party. Vehicle bearing registration number AS
01 BD
01 BD 2314. Coming from the side of Dimapur towards Borkotat. Section 50. Notice is at page 60. Copy to not in conformity with the provisions. In view of the law laid down by. And Kumar. Saradika. Build up.
I am obliged. My lord, this would be, might be my last appearance here, lordship, my lord, on the occasion of your lordship. So I convey my best wishes.
Anyway, we don't know when you have to leave.
May I please, your lordship, the 482 bail application.
21, my lord, petitioner is in interim, my lord, case diary not yet received.
Why this pre-arrest bail application was already disposed of? On 11/11/2024. Why it has been listed again? By an order dated 11/11/2024. This pre-arrest bail application filed by the petitioners in Sonapur Police Station, case number 275/2023. Was already disposed of. Directing would-be petitioners
Lordship, the
as,
this number is
as
274. This is 11 of 2025. I think 21.
21.
Yes, this is 11 of 2025.
21 to AB 120/25.
But yes, this to the 375.
the person. Petitioners namely such and such and such. The apprehending their arrest, the petitioners namely such and such. File this bail, pre-arrest bail application on 10/01/2022. Praying for the pre-arrest bail in Sonapur case number such and such and such.
Yes.
Report.
Yes, yes.
By order.
Mhm.
23/01/2022. Link for the case. Granted interim bail to the petitioners. Directing them to appear before the concerned investigating officer within 10 days. On 11/11/2024. The court observed that by charge sheet number 71 dated 21/04/2024. Police submitted the charge sheet in said Sonapur case number 275 of 2024. As such, the court by the said order dated 11/11/2024 directed the three petitioners disparate their application to approach the appropriate forum for their regular bail. In Sonapur case number 275 of 2024.
This is Hosai PS case number 1125.
Yes, Lordship.
Which one?
The present, my lord, item number 21, Rajibul Hussain.
Yes.
Something is wrong. Because the case is before us is of AB number 120/2024, Ikramul Haq and others.
No, my lord, here not Ikramul Haq, my lord, Rajibul
Rajibul
Hussain.
Hussain.
The dispose of case take put it. Particular number. Proof rights, so the section of penalty equal dispose of case. Dispose of লেখা দিছে dispose of বুঝে। No, এটা তো dispose of what data আছে, dispose of what section উপর separate case এটা কেন কে আহিল? লেখা। The item number 21 in the cause list, AB 120 of the 2025. Nala. Rajibul Hussain versus State of Assam. Shown. Whereas the registry has forwarded the record of AB 120/2024. Ikramul Haq and two others versus State of another that was disposed of on 23/01/2024. The registry shall verify unless the appropriate matter on second of June. No, he took it. Registry should have it. No. Hospital can I will order secret effect. Petitioner, the registry has for that funnel. Definitely. Sorry. 22. Come to order secret money. Dispose of order secret money kill.
Lordship, in item number 21 interim is there, Lordship.
That
Okay,
item is not
order-
before us.
Okay,
That is the reason we cannot write any order in any of the order sheet. So that case is not before us.
My lord, in this case, my lord, the up-to-date case was called for, my lord.
My lord,
Yes,
yes,
Mr. Dhingla.
my lord, it is received, my lord, or my lord, the statement of the accused man. It is recorded, my lord, it is before.
Now tell us whether he is required in the custodial interrogation or that is sufficient because he appeared and he is in.
APR mal is cooperating. my lord.
Not Mr. Alan Dehia, counsel appearing for the petition. Petitioner Amrit Das alias Patil filed this previous bail application after ending his arrest in South Guwahati Ranch, Lokta Police Station, FIR case number, forest offense number SG/13 of 2024-25 under section 24, 25, 34, 35, 40, 41 and 49 bracket 1 of the Assam Forest Regulation 1891 amended in 1995. The court by order dated 07/02/2025 granted interim bail to the petitioner inside South Guwahati Ranch, Lokta Police Station, FIR case number, forest offense number, set case litigation, forest case. Mr. B. Sharma, Special Public Prosecutor, Forest. State of Assam, have submitted that after obtaining interim bail, the petitioner appeared before the concerned investigating officer of the case and his statement has been recorded. And that the petitioner is cooperating with the investigation of the case. In view of the interim bail granted to the petitioner on the custodial detention, the petitioner not warranted in the same South Guwahati Ranch Lokta Police Station is not ready. According to that, counts for the compliance of the rights needs of the realm and also the compliance sections and such.
Master level.
Executive session. 24 my lord, charge sheet submitted my lord, in this case.
Against whom?
Against the present petitioner also my lord, submits charge sheet submitted.
Apprehending his arrest, petitioner namely such and such. And apprehend and recuse. Paid for his pre-arrest bail in such and such and such. During deliberation of the matter, Mr. P. Botaku, additional public prosecutor submitted that on completion of the investigation, the concerned investigating officer submitted the search sheet in said Goripur Police Station case number 54/202. Charge sheet number
Charge sheet number my lord, 134/25 dated 21/4/25.
2104
Yes, ma'am.
against the petitioner, accused, petitioner and the other co-accused of the case. In view of the above, petitioner may approve the appropriate importance, regular variance of
Maybe. Medical report was
Yes,
also.
yes. What is the medical report?
Well, medical report, my lord, not yet received, ma'am. Victim is minor, my lord, date of birth 1/7/2008.
So on the date of the incident, she was a minor.
Yes, ma'am.
May I
minor.
know the date of issue of the birth certificate, my lord?
16 years, 7 months. My lord, birth certificate is available in the case diary.
Yes, ma'am. By order dated 19/05/2025, the medical report of the victim girl, minor victim girl, was called for as that was not found available in the case diary pertaining to Ojai Police Station case number, sorry, Lumding Police Station case number 21/2025 under section 87/69 BNS reduced section 4 of the POCSO. Fixing the matter today. Mr. Botakul, on addition of the prosecutor, P. Botakul, submitted the said medical report of the victim girl is yet to be received. Placed on
My lord,
18th of June, enabling the concerned investigating officer of Lumding cases police station for review to place the medical report of the minor victim girl, failing which she has to personally remain present before the court at 10:30 AM. Copy of this order be furnished to Mr. P. Botakul for his necessary use. Placed accordingly on such and such.
May it please your lordship. Anticipated bail application. I filed wakalatnama today, my lord, so I'm appearing today.
You are appearing for whom?
For the petitioner. Informant is also there, my lord. Case there is perhaps also available.
Not necessary of the.
No, my lord, I'm ready to argue the matter, my lord. I'm just informing that I have.
Oh,
My lord, will find the FIR at page 10. Basically, my lord, three documents I would like to point out to your lordship, my lord. One is the FIR which has been lodged against me, my lord, on 17/4/2025, accusing me of offence under section 8 of the POCSO Act. Prior to that, my lord, 5 days prior to that, my wife had already lodged an FIR against that informant, my lord. The informant and my wife are colleagues, my lord, in a school. And there was an incident involving the informant and my wife, following which my wife lodged an FIR. Subsequently, my lord, all the headmistress of the school has also given a complaint against the same informant, my lord, my wife's colleague, before the block elementary education officer, my lord. After this episode, my lord, this FIR was lodged. In fact, the girl was also taken before the CWC, my lord, wherein she also stated the CWC order, my lord, we have also annexed, my lord, page 35, that there was a dispute between her father and my wife, my lord. So this FIR was belatedly lodged because of the initiation of the complaints as well as the allegation made before the BEO by us. Page 10 is the FIR lodged against us. Against me.
Yes, Mr. Bhattakur, kindly give it to us.
Yes, sir. My wife's FIR is at page 16, my lord. In CWC, my lord, there's an additional affidavit also from our end, my lord. Additional affidavit, your lordship will find the letter to the BIO at page 31, BEO. And the CWC orders, my lord, at page 35.
What do you have to say?
My lord, we have filed a written objection on behalf of respondent number 2. Rest I leave it before your lordship.
Burwa.
Lordship will kindly appreciate the chronology of the events, my lord. How this FIR was has come to be lodged, my lord. On 12th, my wife lodges this FIR.
No, because it is related. No, until school.
On 12th, my wife lodges the FIR, my lord, alleging physical intimidation against the informant, respondent number 2, my lord. These are all subsequent fallout of that FIR, my lord. They have been alleging that we have been harassing her for 1.5 hours, my lord, or half years, my lord. And they don't lodge an FIR during this 1.5 years. They lodged it only after my wife lodges an FIR against the respondent number 2, my lord. In fact, the CWC order also reflects that part, my lord, that the victim had stated, note number was there in the 183, but in before CWC, she stated that the whole issue was because of a dispute between her father and my wife, my lord.
Yes, give it to us. Heard Mr. S. Nawaz, learned counsel, who has entered appearance on behalf of the petitioner. Also heard Mr. B. Bakapu, under additional public prosecutor, appearing for the state section. Also, good evening.
Yes, yes, sir.
And Mr. S. Ahmed, learned counsel, for the respondent number, opposite party number 2 informant, mother of the alleged victim, mother of the minor victim. Apprehending his arrest, the petitioner namely such and such and such. For his previous bail in the Boca Police Station case number such and such. Under section 8 of the POCSO, corresponding to GR number 393 of the 2023. As for the FIR dated 1704-2024-25, lodged by the informant before the Boca Police Station. The case is that our daughter, 14 years old, studying in class 9 in a school in where the accused petitioner is a teacher, and since some times back the accused petitioner is to torture her minor daughter physically and mentally. Though daughter was initially silent, but as such physical and mental torture increased on her by the accused petitioner in PSD. She informed everything and the acts done by the accused petitioner on her informant, like touching her or giving a different /awe look, pulling her in her hand and indicating her in different way. Is to stalk her STL. The accused petitioner even directed her to leave the said school. And as such, and for all this, her minor daughter is facing depression, is under depression. The said affair was the informant was accordingly registered as the Boca Police Station case number 76 of the 2025 under section 8 of the POCSO against the petition. Mr. Nawaz, learned counsel, appearing for the petitioner submitted that earlier on 12/04/2025, a fellow teacher of the school lodged an FIR against the informant,
Informant's husband, madam.
Against the informant's husband,
Well, just one submission, madam. This fellow teacher is my wife, madam.
fellow teacher, Komalika, wife of the present accused petition, lodged an FIR against the husband of the informant That was registered as what?
Doboka PS 72 of 25, my lord.
Doboka PS case number 72/2025 under sections.
Sections, my lord, we are not aware because of intervention, police apprehension, we cannot go there, my lord. Oh, my lord, I have the section, my lord.
So-
Sorry, my lord, 296/74/351 2 of the BNS, my lord.
Repeat it again.
296, my lord, /74, my lord, /351 subsection 2,
351 of the BNS.
BNS, my lord.
And the counterblast of the same Doboka PS case number 72/2024. The informant has lost this affair against the accused petitioner. Mr. SS Ahmed Learned Counsel appearing for the informant by filing an objection objected the pre-arrest bail of the petition. Peruse the case study placed before the court by Mr. P. Bhattakur, an additional public prosecutor appearing for the state. Also seen the statement of the minor victim girl recorded under section 183 BNSS. Recorded by learned judicial magistrate first class. Ojai Sankadev Nagar on 23/04/2025. Also peruse the statement of the independent witnesses so far recorded by the concerned investigating officer of the case under section 181 of the BNSS. Available in the case there. Considering such materials indicates that the court is of the view. It is also seen that no, no, all right. 40,000 to local security. One of which will be government districts. Back POCSO conditions. Shall not come to the shall appear before the concerned investigating officer of the case. On or before 9th of June. And thereafter at the 9th of June, declared today is 28th, no? 4th of June. Thereafter such and such. Return the case.
I'm deeply aware, my lord.
Come to the vicinity.
So dispose of, my lord, dispose.
Return the case there.
My worship.
You have a case there, Mr.
My lord, case,
Worship, we will file an additional affidavit. The petitioner Faisal Islam is suffering from TB. So I did.
On the prayer of the council for the petitioner, matter be listed after 2 weeks immediately be fixed.
I'll retain the case, my lord.
Oh, yes, we'll pass the order to the floor.